litigation, especially given the extensive delays in court?
Before I answer to this question, I would like to express my gratitude to the founder of ILA for organizing this such wonderful event to speak on the topic of litigation and dispute resolution. So first of all, the purpose of arbitration was to resolve this matter as expeditiously as it could be, so that the minimum judicial intervention could have happened, but it is not actually taking place. In my short span of 12 years in this legal profession, I have been handling criminal trials, civil trials, and arbitration matters also I have been handling. So, if I take an example of Section 29B, which talks about fast track of arbitral award, specifically which gives a time limit of disposing the arbitral award, which is 6 months. If we don't decide the award under 6 months, then an extra time has to be given. But generally it doesn't happen. The arbitral award, it gets disposed of within the period of 6 months. Now, what are the advantages of arbitration and mediation? The advantages was the speed, the quickness of technical expertise, the finality of the award which talks about the finality of the awards which have to be disposed of by the arbitrator, that is the final. So now, the finality of the award can also be challenged in the court itself. So the pendency of arbitral award has been increased over the past few years. Now, few things that can be done to make this more viable is that if you file, generally the landowners which files an appeal under Section 34 before the civil court, the principal court of original jurisdiction, which is the district court, is the main court. Now what they do is, if an arbitral award has been passed, and then the landowner, who is the petitioner here, they challenge the award before the district session court. Now the hearings kept on pending for many years. The hearing doesn't take place. Now if the party is a state government, to the other side, they also take adjournments on several occasions. Now the finality of award that has been already been decided by the arbitrator, which it doesn't conclude on within the time period. So actually arbitration has always been a mechanism which needs to be considered by the several arbitral tribunals. That has not been taken care of. Recently, after amendment of Arbitration Act, the Arbitration Council was also proposed in the provision. So there are 6 or 7 arbitral tribunal has been established in India. Now, if I talk about a case law with respect to this arbitration, this is a case of Supreme Court Nalco case, which was decided already in 2024 itself, which talks that the number of limit in passing an award in the execution proceedings has to be decided by the civil court. Now the court has stated in this Nalco judgment that if an appeal under Section 34 is pending before the court doesn't take any action on it. So it has recommended an idea that at least an interim order can be passed by the civil court, so that the time could not have been wasted in disposing of the arbitration petition. In mediation, if you can see, the Mediation Act has also been passed in recently. The Section 48 states that, which specifically envisages the power to the central and state government, that you have the power to frame these schemes and guidelines. So the power has been shifted to state and central government in framing of guidelines with respect to the mediation settlements. And the same goes to Section 49, which states that until and unless the competent authority of the state government or the central government, the permission has not been taken and the sign has not been taken from the competent authority, the mediation settlement cannot be enforced. So we have to see that if these two things can be considered in longer run, that would be really helpful.
Thank you.